Well, it's good afternoon again, and this is Stuart Ryan with the Ryan Report. Uh, Yesterday, I was completely happy to go off all of the topics currently in the news that have to do with the Trump regime and corruption, totalitarianism, and the complete destruction of the administrative state. But sadly, today's news changes everything because we have a judge in Western Pennsylvania named Stephanie Haynes who's just decided that the Alien Enemies Act of 1798 is applicable in the current circumstances and enables the Trump regime and all the Nazi sycophants attached to it to continue charging people under that act, despite the fact that three other judges have said it was perfectly fruitless, pointless, and unlawful.
A federal judge in Pennsylvania ruled in favor of the Trump administration Tuesday over its use of the Alien Enemies Act to deport some Venezuelan migrants. Trump-appointed Judge Stephanie Haynes said the president may use the 18th century wartime law to remove Venezuelans older than 14 who are accused Tren de Aragua gang members, but with a caveat. She ruled the administration must give 21 days notice to potential deportees if it invokes the act, rather than the 12 to 24 hours it had been given. Earlier this month, federal judges in New York, Colorado, and Texas ruled against the Trump administration's use of the act. They said the move is illegal because the government hasn't provided sufficient evidence of an invasion or predatory incursion required under the law. CBS News immigration and politics reporter Camila Montoya Galvez joins us now. So the judge here, in this case, Judge Haynes, found that the gang Tren de Aragua is committing a, quote, predatory incursion into the U.S. We mentioned other judges disagree with this. So where does she differ with these judges and what happens next?
Well, this is the first time that a federal judge, Lindsay, has found that the Trump administration had reasonable and sufficient legal grounds to invoke the Alien Enemies Act of 1798 to arrest, detain, and deport suspected members of Tren de Aragua. That is that Venezuelan prison gang. And the administration has been making this extraordinary argument in court that this transnational gang has been orchestrating an invasion or an incursion into the country. She said that, yes, this gang is, in her view, orchestrating an incursion into the country, and she mainly relied on the fact that the State Department has designated Tren de Aragua as a foreign terrorist group. And so she relied on that determination to find that this is an incursion by this gang and that the Trump administration can actually invoke this law to target them and to arrest and deport suspected members of this organization. But this ruling does not apply nationwide, and it does not allow the administration to continue using this law to deport people across the country.
Is it only her district?
Yes, in the Western District of Pennsylvania. And ultimately, this case will be decided by the Supreme Court, which is weighing this very same question. How much due process do people process under this law get, and whether the administration has satisfied the necessary legal requirements to invoke it in the first place?
Now, having seen that and considering everything about the Alien Enemies Act 1798, which really is the most simple and direct act, I have to add all the caveats. The Supreme Court, no, it has not considered the viability or the validity of utilization and invocation of this act in order to deport and imprison alien immigrants without there being a declared war or a predatory invasion based on a declared war or by a nation or state. Section 1 of the Act is clear as hell. But the arguments that are going to be made eventually in the Supreme Court are going to revolve around Trump administration's plea that this is a political question and not reviewable by the court. And I have many fears about this. The doors will be wide open for a fascist Supreme Court. These monsters in black robes, the 6 of them, to back the Trump administration and allow this act to be utilized. I have compiled some more information, but it makes it arguable. However, the argument should fail, especially if the judges or the justices are originalists. The plain language of the act speaks for itself. But there we have it. So until another day, another disaster, this is Stuart Ryan saying goodbye.